Customs fines are imposed for shortages or over-discharged cargoes at the ports of Turkey by the customs authorities. At the same time, cargo claims are also very common due to discrepancy regarding the cargo. Discharged cargo quantities are determined at the Turkish ports by shore figures of customs authorities, shore scale or weighbridge. And as a result of such determination, huge claims may be brought by the consignees or at the same time by the customs authority. If shortage or surplus is determined by the customs officers at the Turkish ports, then the customs officers may initiate a customs investigation regarding such cargo discrepancy. Under the legislation in force, if customs authorities allege that there was a cargo shortage or surplus occurred pursuant to Article 3 of the circular, which is published by the General Directorate of Customs, the relevant party, who may be the owners or the managers of the vessel, shall be invited to lodge the necessary documentation along with a petition explaining the reason of such shortage or surplus. The related party shall present such documentation within 3 months in accordance with the same article of the circular. And in addition to that, an additional 3 months period may be granted by the customs authorities upon application. And such extension applications shall be also filed within the first 3 months period allowed. In addition to that, as per the circular, such document explaining the reasons of the exceeding or the shortage amount of the cargo shall be issued by the port management or agents at the loading port in case the same is a governmental institution. If they are not, then the exporter or the party who performed the loading at the loading port shall issue such a letter, and the same shall be approved by the Customs Directorate, Chamber of Commerce or Chamber of Industry or the Harbour Master at the loading port. In the event of lack of documentation or sufficient explanation, or if the customs authorities are of the opinion that the submitted documentation or explanation is not sufficient, then the customs authorities may initiate an administrative investigation against related parties as per the Article 75 of the Customs Regulation. In addition to that, the customs authorities may consequently impose a penalty as per Article 237 of the Turkish Customs Code. The amount of the related administrative fine will depend on the type of the cargo, amount of the cargo, on its customs tariff, on its customs value, and the same will be also calculated as per the same article by the customs authorities. If the imposed administrative fine is paid within 15 days as of the notification date of the subject fine, then a reduction of 25% is automatically applied. Within the same period, an application for paying the subject fine in installments can also be filed to the customs authorities. The party against whom the administrative fine is imposed is also entitled to challenge the fine by applying to the higher authority of the administrative body which imposed the subject fine. Such objection can be filed within 15 days as of the notification date of the related fine. And if the application is dismissed or is simply or implicitly deemed to be dismissed in the lack of any reply, which normally should be received within 30 days upon application. An administrative claim may be commenced before the competent administrative court upon application for the cancellation of the fine. It is also important to note that filing an objection against the subject fine will not block the enforcement of the administrative fine. In other words, although you file an objection against the fine, you will be required for the payment of the same in any event.